Okay, welcome back. This video, I just want to focus on patents and basically make sure that you've got a solid understanding of what a patent is and the policy reasons for it, and basically start to think about what this might mean in the context of AI, big data, and blockchain. So a patent is a form of intellectual property that grants inventors exclusive rights to commercially exploit their inventions for a limited period, a statutory monopoly. It's different from copyright, which protects creative expressions. Patents protect inventions. So these could be new products, processes, methods, new ways of doing something, or which offer a technical solution to a problem. Patents are governed by the Patents Act 1990, and protection is granted through the regulator IP Australia. That's the government body responsible for managing patent application. Patents aren't covered in as much detail on Canvas as copyright is, so much of the content in this presentation you won't have the backup of the material on Canvas. So what is a patent? A patent provides its owners with exclusive rights to use, sell, and license an invention for a period of time, that statutory monopoly period. And ultimately, that means it prevents others from using or copying the invention without the permission of the patent holder. This exclusive right incentivizes innovation by allowing inventors to benefit financially from their creations, to exploit the intellectual property rights by holding the patent and then deciding who can buy it, who can license the technology, how it can be used. So let me give you an example. There might be a patent on a new type of medical device that performs surgery more efficiently, and that gives the inventor of that device a monopoly over its manufacture and its sale. Let me just make sure that you can see this. So this is the key point, that exclusive right to use, sell, and license. And ultimately the period is 20 years. So that's for a standard patent. Technically, there are two types of patents in Australia. Standard patents that provide protection for up to 20 years and require a more detailed examination to confirm that the invention meets all the legal requirements. Up until August 2021, there were also innovation patents. These offered protection for up to 8 years, and they were designed for incremental innovations, but these have been phased out. So while some of them still exist, it's not possible to get a new one. So what can be patent? It needs for something to be eligible for patent protection, an invention needs to meet a range of criteria. And the key ones are novelty. So the invention needs to be new and not previously disclosed to the public. Secondly, there needs to be an inventive step. It needs to be something that's not an obvious improvement on an existing technology. And thirdly, it needs to be useful. It needs to have utility. So the invention needs to be useful and capable of being made or used in an industry. So all those criteria are really important, and the one that often becomes problematic for business is novelty. When people have a new idea, something that they think could turn into an invention, often, particularly if they need to raise money to fund their invention or fund the next step, they're telling people about it. And as soon as it becomes public, it can't be novel anymore. So basically, there are real benefits ensuring that if you're inventing things that you need to keep them a secret. So how are patents protected in Australia? Let's have a look. Basically, there's an application process. So patents are granted and protected through IP Australia, which manages the application, examination, and enforcement processes. So the patent application process involves a number of steps and starts with filing. So the inventor needs to file a patent application with IP Australia, and that needs to incorporate a full description of the invention. Why is that important? Essentially, the public policy is that in exchange for sharing your invention with the world, telling people how it's done, the world, in this case actually the particular jurisdiction, will grant exclusivity over the exploitation of that invention for a period of time. Now, already you've noticed that actually we're talking about Australia, Australia. And so that will just grant exclusivity in Australia. There are through those international conventions, the opportunity once you file in one place to get your start date for filing applications in other jurisdictions as well. The next step is examination. So IP Australia, or the Patents Office in any relevant jurisdiction, will examine the patent to ensure that it meets legal requirements, so the novelty, inventiveness and utility. And then once it's approved, so the patent will be granted when it's approved, giving the inventor exclusive rights for the duration of the patent. So that's basically 20 years from the date. I'm here, again, it'll depend on the jurisdiction, but 20 years from the date of the grant or the date of the application for the patent. Once a patent is granted, the owner has exclusive rights to manufacture, to sell or license, or to enforce the patent. So that includes taking legal action against those who infringe their rights. As I mentioned before, standard patents, they last for up to 20 years, provided that the renewal fees are paid. For pharmaceutical inventions, this can be extended by up to 5 years. Innovation patents these days really are being filed out. And what's important here is to make sure that you're aware that there are processes that need to be followed in order to maintain a patent as well. So that includes periodic renewals and paying maintenance fees. So as a business, what kind of questions do you need to be asking? Patents provide broad protections, but of course there are limitations. Patents don't grant a global monopoly. Inventors need to apply for patents in each country or jurisdiction where they're seeking protection. And in certain conditions where the public interest is such that IP Australia or the government generally considers that there is value in or a requirement to share that particular patent, the government may allow others to use a patented invention without the owner's consent. Some of the considerations for businesses that are seeking patent protection include international protection. So because patents are territorial, businesses need to consider filing patents in multiple countries if they intend to operate in those countries. These can be done through the Patent Cooperation Treaty, the PCT, which simplifies filing in multiple jurisdictions. Secondly, monitoring and enforcing. So just like with copyright, businesses need to actively monitor the market to see whether or not their patents are being infringed and to enforce their patent rights, whether through licensing agreements or, of course, they can take legal action. There are significant costs in relation to protecting inventions using patents. The cost of obtaining and maintaining a patent can be really significant, especially for businesses that need to seek protection in multiple jurisdictions. Legal advice is often necessary to navigate the process effectively. So let's talk about the Thaler DABUS case. This is a case that, so the same litigation or similar litigation was undertaken across a range of different countries, and it was essentially a test case to raise a critical legal question about the recognition of AI-generated inventions under patent law. So Dr. Stephen Thaler, his face is on the screen, he applied for patents in a number of jurisdictions and basically named the AI system that he had put together, something called DABUS or DABUS, the device for the autonomous bootstrapping of unified sentience, DABUS for short. Anyway, DABUS was named as the inventor. So this AI had created two inventions, a food container and a neural flame for use in search and rescue. The central legal issue is whether artificial intelligence could be recognised as an inventor under patent law, given that the patent systems traditionally assume a human inventor. So the human inventorship requirement, the legal principle is that under most patent laws, inventorship is limited to humans. Courts and patent offices in multiple jurisdictions have ruled that for a patent to be granted, the inventor needs to be a natural person. So a patent can be applied for by a company, so a legal person, but the inventor needs to be a human person. The Thaler case highlighted this long-standing requirement under Australian law. So in Australia, the federal court initially ruled that Thaler, that AI could be recognised as the inventor. And the reasoning that Justice Beach gave was that patent laws should evolve to reflect technological advances. Ultimately, this decision was overturned by the full federal court, which ultimately ruled that current legislation requires a human inventor, basically throwing it back to the legislation or legislature and essentially saying to the government, if you want to protect inventions that are made by AI, then the law needs to be clear that that's what the case is and that legislation needs to be changed. The decision underscores that patent law, as it stands, doesn't accommodate non-human inventors. The courts focused on the language of the statutes, which consistently assumed inventorship as a human activity. So let me actually show you. So on the screen now, you can see kind of an overview summary of what the law actually says. So these provisions, because of, even though the patents are in many different jurisdictions, the laws are not the same, but they are similar in each places as a consequence of the operation of treaties, and also the fact that even though patent is a creature of statute, the statutes have been around for a very long time, and even when they've been replaced and modified over time, we've got hundreds of years of inventorship. So the courts in the various jurisdictions emphasise the importance of interpreting the patent laws in line with the original legislative intent. Patent law was historically developed around the idea of human inventors, and changes to accommodate AI inventorship will require legislative action. The full federal court's decision to overturn Justice Beach's ruling was based on its reading of the Patents Act, where the court found that it clearly assumed that the inventors would be human. The court concluded that it was not its role to redefine the law, but rather this is the role of the legislature. In relation to ownership and control, even if an AI could generate inventions, there are unresolved issues regarding who owns the rights to those inventions. Dr. Thaler argued that as the owner and operator of DABUS, he should own the patents that are created by the AI. But the court struggled with this concept, as patent laws typically require the ownership to be tied to the inventor's contribution. If the AI is the inventor, who rightfully controls the resulting intellectual property? Now, there's global significance here. The principle points to a broader set of uncertainties about how intellectual property rights will be allocated in the context of AI inventions. And we need to be thinking about whether the developer of the AI, the user of the AI, or some other entity should be granted ownership. Or the other outcome could be that inventions made by AI are in the public domain and that nobody actually owns them. So just looking, I've mentioned this international focus because these test cases were run in a number of jurisdictions, and I just thought it was worth highlighting what happened in each of them. In the US, the US Patent and Trademark Office, so USPTO, rejected Thaler's application, affirming that under US patent law, only natural people can be inventors. This decision was upheld by the US District Court in a case called Thaler and Hirschfield in 2021, and the court pointed to the statutory language similarly to the full court in Australia. The European Patent Office, the EPO, also rejected Thaler's application, concluding that AI cannot be named as an inventor under the European Patent Convention. The EPO emphasised that the term inventor is legally defined as a natural person, and AI systems do not meet that definition. However, in its ruling, the EPO noted that the patent system was established to incentivize human ingenuity, and recognizing AI as the inventor would require significant changes to the legal framework. In the UK, the Intellectual Property Office rejected the DABUS application for similar reasons. The UK High Court upheld the decision, ruling that a patent law requires human involvement in the inventive process. The court acknowledged the increasing role of AI in innovation, but stated that the current law does not allow for non-human inventors. So you can see that the initial decision of Justice Beach in the federal court was an outlier. It temporarily recognised in Australia the idea of AI being an inventor under Australian law, but the decision was relatively quickly overturned by the full federal court. Thaler sought leave to appeal to the High Court, but the High Court rejected that application, saying that the law was clear. In South Africa, so South Africa is the first country to grant a patent listing DABUS as the inventor, but this is seen more as an administrative decision at this stage rather than a legal precedent, because the South African system doesn't have a substantive examination process like other jurisdictions do. So there's a range of policy issues that are coming up here. So Thaler and DABUS, this case recognises the need for legal systems to consider how to handle AI roles in innovation. The case itself and really the ongoing evolution of AI and the way we're seeing it being used has raised important questions about the extent to which AI laws, intellectual property laws, I should say, should need to be adapted. Should the patent law evolve to recognise AI's contribution? And if so, how should the ownership be structured? Current patent laws are designed to incentivise human creativity and human investment. Allowing AI to be recognised as an inventor could disrupt these incentives, raising concerns about the future of innovation. Or perhaps they could incentivise the creation of stronger, more robust AI for significant advantage. There's also the questions of legislative change. Many jurisdictions have noted that legislative changes would be required to allow AI inventorship. And this is suggesting that patent laws globally aren't equipped to deal with the issue without significant reforms. So I've got a little slide here at the end, which is kind of summarising the key issues here, but I think I've really spoken about this in enough detail. So have a look at the slide and do come back to me with questions, concerns, frustrations, suggestions or compliments if you have more. But it's really time for us to finish up now so that we can move on to the final recording for this week, where I get to interview a former student who is now an IP lawyer working at a mid-sized law firm, and we have a really interesting discussion about what's happening in practice with these emerging technologies when it comes to intellectual property. So I look forward to seeing you there. Cheers.